So good morning to all. Good morning to all. Right? I'm sorry for delay. ఎట్లా లాస్ట్ క్లాసే కదా పాలిటీకి. రైట్. So in today's class, let me talk about the extra constitutional bodies. Extra constitutional bodies. Alright. So when we talk about, right, when we say it as extra constitutional bodies, it includes both, alright, statutory bodies as well as and executive bodies. Alright. So remember, it includes both statutory bodies and executive bodies. Alright. So first of all, what do you mean by statutory bodies? Alright. So if you take this meaning of statutory bodies, so statutory bodies are those bodies which are created by a law of parliament. Statutory bodies are those bodies which are created by a law of parliament. Alright. So this is what the meaning of statutory bodies. Right. So statutory bodies ante it is those institutions which are created by a law of parliament. The best example of these statutory bodies are, it is NHRC, National Human Rights Commission. Alright. NHRC is one such example. NHRC, CVC, all public sector undertakings. Alright. All public sector units. Alright. So they come under statutory bodies. Right. So statutory bodies means those which are created by law of parliament. NHRC, CVC. Alright. So these are the examples. Now coming to executive bodies. So executive bodies means those institutions which are created by a resolution of cabinet. Right. Those institutions which are created by cabinet resolutions or simply the decisions of government. Right. So government నిర్ణయం ద్వారా create చేయబడ్డ institutions. Right. That is the meaning of executive bodies. Right. So executive bodies are those institutions which are created by a resolution of cabinet or a decision of cabinet. Right. A resolution of cabinet or a decision of cabinet. Alright. So, alright, the best example of this executive bodies are Niti Ayog. Right. So Niti Ayog is the best example. Of the executive bodies. Alright. So we have Niti Ayog, government companies. Even government companies, the difference between government corporations and government companies is that government corporations are created by law of parliament, whereas government companies are created by executive decisions. That is a major difference between corporations and companies. So when you talk about corporations and companies, first of all think about their creation, how they are created, avi ela create cheyabaddayi. Corporations antenemo those institutions which are created by law of parliament, whereas companies are created by the executive decision. So there is what you call there is one act. So Government Companies Act of 1955. Right. there is Government Companies Act of 1955. So based upon this, by using this Government Companies Act of 1955, the government of India is empowered to constitute companies, to create companies. It can purchase shares or it can take up any private company and mix it with the government. Right? So that is one power. So now first let me talk about statutory bodies. So in this class, so in polity, I will discuss these statutory bodies. Alright, that is, I will start with NHRC, National Human Rights Commission. I will start the topic of National Human Rights Commission. Alright. So if you take this National Human Rights Commission, the name itself says, alright, the name itself, says it is a commission that is meant to protect human rights. That is meant to protect human rights. Right? So apart from Supreme Court, apart from judiciary, even we have judiciary. Alright? So judiciary is the constitutional entity. Judiciary is the constitutional entity to protect the rights which are given by Constitution. Right? Particularly those rights which are mentioned in Part 3 of the Constitution. If you take judiciary, already judiciary unnadi kada sir, Supreme Court unnadi kada, malli National Human Rights Commission lanti vyavasthaku avasaram entidi. So you may get this doubt. You may get the doubt that what is the need for having such a commission again. Remember, if you take this judiciary, the judiciary is meant to protect the rights, right, which are conferred by Constitution. It is meant to protect the rights given by Constitution, and that too particularly those rights which are mentioned in Part 3 of Constitution. Those rights which are mentioned in Part 3 of Constitution. So what is Part 3? What does Part 3 deals with? Those rights which are mentioned in Part 3 of the Constitution. So what Part 3 deals with? Fundamental rights. So Supreme Court or High Court or the judiciary, it is meant to protect these fundamental rights. They are meant to protect fundamental rights. Alright? And there is a protection given in the form of writs. Then what about the rights which are given by a law outside the Constitution? Right? Say for example, I'll take one issue. The rights of refugees who are staying in India. Alright? That is, all those illegal migrants who are taking shelter in India. Alright? Asylum seekers. So if you take Indian Constitution, we don't have any specific rights mentioned about refugees or asylum seekers. Right? That is those who are staying in India illegally. That is, and those people who are being given shelter by India. మరి వాళ్ళ గురించి మన కాన్స్టిట్యూషన్ ఎక్కడ మెన్షన్ చేయలేదు కదా. ఇవే కాకుండా if you take the rights, alright, so rights other than given by Constitution, that is rights given by law of Parliament. Say for example, చిన్న ఎగ్జాంపుల్ తీసుకుందాం. Wife and husband, they got divorced, or there is a harassment of women. Alright, dowry harassment చూస్తూ ఉంటాం, any kind of harassment, divorce cases, lack of protection from the family. So these are the issues which are not covered in Constitution, but we have a law made by Parliament. So if you take Domestic Violence Act, right, we have Domestic Violence Act. Alright, so Domestic Violence Act, it not only protects the women but also it provides certain rights to women. Alright, అది విమెన్ ప్రొటెక్షన్ ఒకటే కాదు, రైట్, ఇట్ ఆల్సో ప్రొవైడ్స్ రైట్స్. మరి ఇలాంటి రైట్స్ని ఎవరు కాపాడాలి? సో నార్మల్లీ judiciary has the role, but it comes under ordinary jurisdiction, not under writ jurisdiction. Right? They are not fundamental rights. They are the rights given by law of Parliament. Right? Law of Parliament. Alright? So you take anything. Normally we see teachers punishing the students. teachers punishing the students. It is a violation of the human right. Alright, so these are not covered under constitution. Right, that means, so this commission, this National Human Rights Commission, human rights commissions, alright, they are meant to protect all the rights of individuals, that that ensures well-being of individuals that are essential for human existence. రైట్, ఒక మనిషిలాగా బ్రతకడానికి కావాల్సిన అన్ని రైట్స్ని ప్రొటెక్ట్ చేసే బాధ్యత హ్యూమన్ రైట్స్ కమిషన్ది. రైట్, సో ద పర్పస్ ఆఫ్ హ్యూమన్ రైట్స్ కమిషన్ ఈజ్ టు ప్రొటెక్ట్ దీస్ రైట్స్, దట్ ఈస్ those rights which are conferred by a law of parliament, those rights which are outside of constitution, that is which are outside of what you call the rights given by constitution. So it is with that intention, these human rights commissions are created. అవి కూడా ఉంటాయి. లోక్ అదాలత్ ఇస్ డిఫరెంట్. లోక్ అదాలత్, లోకాయుక్తాస్, right, these are, right, if you take this lok adalat, normally they deal with the civil cases, right, they are meant to adjudicate civil cases, right. But coming to human rights, so these human rights commissions, right, human rights commissions are specialized in rights of the individuals, right. It is not the ordinary litigations, it is those litigations where there is a issue of rights of individuals, right. So lok adalats are also involved in adjudication, but they are not specialized institutions, in human rights or rights of individuals. It is to reduce the burden of regular judiciary, ordinary judiciary. So we have the issue of pendency of cases, right, and today we see increase in the number of petitions. To reduce the burden, so we are having these mobile courts, lok adalats, the family, initiatives taken, right. It is only to share the burden of ordinary judiciary, right. So that is what the purpose of lok adalats, right. So now coming to this human rights commission, right, the purpose of human rights commission is to protect the basic rights of individuals. It is to protect the basic rights of individuals, all right. So for the first time in India, all right, this National Human Rights Commission, for the first time in India, the National Human Rights Commission was created in 1993, right. A law was passed, right. A law was passed in 1993, right, in Parliament, which is called as Protection of Human Rights Act, right. So remember, it is under Protection of Human Rights Act this National Human Rights Commissions as well as State Human Rights Commissions are created, right. It is Protection of Human Rights Act of 1993. Protection of Human Rights Act of 1993, which is the basis for NHRC. So NHRC is created, right, based upon this law, right. So if you take this composition of NHRC, if you take the composition of National Human Rights Commission, so National Human Rights Commission consists of chairperson and 5 other members, right. It consists of chairperson and other 5 other full-time members, all right. 5 other members who have a knowledge of human rights, that is the expert members or the persons who have the knowledge of human rights are appointed by President of India. Remember, it is President of India who appoints chairperson and other 5 members to the Human Rights Commission. So, and it is the retired CJ of Supreme Court, right. It is retired Chief Justice of Supreme Court who is appointed as chairperson of Human Rights Commission. It is a retired CJ. It is retired CJ of Supreme Court, right. It is retired CJ of Supreme Court who acts as the chairperson of, who is appointed as chairperson of Human Rights Commission. Apart from this, what we call 5 full-time members, there are ex officio members appointed to the what we call Human Rights Commission. Alright. So NHRC also consists of ex officio members. There are ex officio members, right, who are appointed. There are ex officio members, right, who are also present in NHRC. Normally, the chairperson of National Commission for Scheduled Castes, Scheduled Tribes, Women, OBC, right, National Commission for Protection of Child Rights, right. So National Commission on Disabled persons with disabled. So the chairpersons of all these national committees, they are also the ex officio members of NHRC. Alright. So మనకి ఇండియాలో ఎన్ని నేషనల్ కమిషన్స్ ఉన్నాయో ఆ చైర్మన్స్ అందరూ ఆ కమిషన్కి సంబంధించి చైర్మన్స్, రైట్. సో ది చైర్మన్స్ ఆర్ ది ఎక్స్ అఫీషియో మెంబర్స్ ఆఫ్ నేషనల్ హ్యూమన్ రైట్స్ కమిషన్, రైట్. సో వీ హ్యావ్ in the previous class we have discussed about National Commission for Scheduled Castes, Scheduled Tribes. ఇవి కాకుండా National Commission for Women, National Commission for Protection of Child Rights, National Commission on Disabilities, right, National Commission of OBCs, right, and minorities. మొత్తం 7 members ఉంటారు, right. So all these are ex officio members. All these are ex officio members of National Human Rights Commission. Alright. The purpose of this National Human Rights Commission is to entertain all those cases. It will take up the case where there is a violation of human rights. Right. So not only this, National Human Rights Commission has the suo motu powers according to 1993 Act. According to 1993 Act, this NHRC has suo motu powers. What do you mean by suo motu powers? Commission taking the case on its own, even without any petition. Petition లేకున్నా సరే నేషనల్ హ్యూమన్ రైట్స్ కమిషన్ తనకు తానుగా కేసెస్ని తీసుకోవడము. మీరు హ్యూమన్ రైట్స్ కమిషన్ తీసుకోండి, మన నేషనల్ ఎన్హెచ్ఆర్సీ తీసుకోండి, ఎస్హెచ్ఆర్సీ తీసుకోండి, దట్ ఇస్ స్టేట్ హ్యూమన్ రైట్స్ కమిషన్. దే ఎంజాయ్ suo motu powers. Alright. Suo motu powers means, right, power to take up the case on their own. ఎప్పుడైనా సరే when there is a issue of gross violation, normally we see rape cases in India. Alright. So petitions లేకున్నా సరే NHRC taking up the case. Alright. NHRC itself will investigate the case. Supreme Court కాదు. NHRC will take up the case. మీడియా నుంచి వచ్చిన రిపోర్ట్స్, రైట్, మీడియాని బేస్ చేసుకొని, మీడియాలో వచ్చిన రిపోర్ట్స్ని బేస్ చేసుకొని ఎన్హెచ్ఆర్సీ తనకు తానుగా ఇన్వాల్వ్ అయిపోవడం, అంటే ఆ కన్సర్న్ కేసుకి సంబంధించిన డీటెయిల్స్ అన్ని తీసుకొని అదే ఇన్వెస్టిగేషన్ని చేయించడము, రైట్. ఇక్కడ ప్రాబ్లం ఏంటిదంటే, రైట్, దెర్ ఈస్ నో సపరేట్ వాట్ యు కాల్ ఇండిపెండెంట్ ఇన్వెస్టిగేటింగ్ ఏజెన్సీ ఫర్ ఎన్హెచ్ఆర్సీ. అంటే ఎన్హెచ్ఆర్సీకి తనకంటూ సపరేట్గా ఇన్వెస్టిగేటింగ్ బాడీ లేదు. ఇదే పెద్ద డ్రాబ్యాక్. ఇట్ కెన్ టేకప్ ద కేస్, రైట్, ఇట్ కెన్ ఇన్వెస్టిగేట్ ద కేస్, కానీ హూ షుడ్ ఇన్వెస్టిగేట్? It can assign the case to any of the agency. It can assign the case to CBI. It can assign the case to the state police. It can assign the case to CID. It is up to NHRC. Endukante NHRC has no investigating body of its own. This is one of the major drawback of NHRC. It is involved in, if you take this NHRC is involved in investigation of cases. It is involved in investigating the cases where there is a violation of human rights. Alright. హ్యూమన్ రైట్స్ ఎక్కడైతే వైలేట్ అయిన రేప్ కేసులు కానీ, లేకపోతే హరాస్మెంట్ కేసులు కానీ, లేకపోతే వయలేషన్ ఆఫ్ రైట్స్ కేసులు కానీ, ఇప్పుడు మీకు అట్రాసిటీస్ ఉంటాయి, అట్రాసిటీ అగేన్స్ట్ SC, STs, women, right, what you call any kind of case. So NHRC can take up the case, but who will investigate this case? this NHRC can assign the case to any of the investigating agency. It can be central agency or it can be state agency. It is up to the NHRC, right? So now చిన్న ఎగ్జాంపుల్ చెప్తాను. థింక్ దట్ NHRC took up a case, right, where there is a violation of human rights. Say there is a custodial death, there is an issue of custodial death. NHRC on its own took up the case. Now think that the investigation of this case is assigned to the state police. Think that the investigation on this of this issue is assigned to state police. Now will there be a rational investigation? Will there be a rational investigation of this case? ఒక కస్టోడియల్ డెత్కి సంబంధించిన కేసు ఎన్హెచ్ఆర్సీ తన సొంతంగా తీసేసుకొని సియోమోటో పవర్స్ని యూజ్ చేసుకొని ఆ కేసు తీసుకొని స్టేట్ పోలీస్కే దాన్ని ఇన్వెస్టిగేట్ చేయమని చెప్పినప్పుడు స్టేట్ పోలీస్ ఆ కస్టోడియల్ డెత్ని రేషనల్గా ఇన్వెస్టిగేట్ చేస్తారా? వాళ్ళు నిజాలు బయటకు తీసుకొస్తారా? వాళ్ళు దే విల్ షో ద వాట్ కాల్ పార్షియాలిటీ, బయాస్నెస్. దట్ ఈస్ దే విల్ ట్రై టు హైడ్, దే విల్ ట్రై టు ప్రొటెక్ట్ దేర్ ఓన్ ఫెలో మెన్, దే విల్ ట్రై టు ప్రొటెక్ట్ దేర్ ఓన్ పోలీస్ ఆఫీసర్స్. అంతే. అంటే అక్కడ ఏంటిది, అక్కడ వాస్తవాలు బయటికి రావు. ఆల్రైట్. సో యూ టేక్ ఎనీ కైండ్ ఆఫ్ కేస్, యూ టేక్ ఎ కేస్ ఇన్వాల్వింగ్ వాట్ కాల్ పొలిటీషియన్స్, కేసెస్ ఇన్వాల్వింగ్ హయ్యర్ అఫీషియల్స్. ఆల్రైట్. సో దిస్ ఈజ్ ద మేజర్ డ్రాబ్యాక్ ఇన్ ద వర్కింగ్ ఆఫ్ ఎన్హెచ్ఆర్సీ. ఎన్హెచ్ఆర్సీ వర్కింగ్లో ఇది ఒక పెద్ద లూప్ హోల్. ఆల్రైట్. సో ఇఫ్ ఇట్ ఈస్ గివెన్ టు సెంటర్, what happens? If the case is given to center, what happens? Again it is the political it is a politics that will come into the issue. మీరు తీసుకోండి, ఇప్పుడు రేవన్న కేసు జరుగుతుంది, రేప్ కేసు. ఇట్ ఈస్ రైట్, దో దెర్ ఈజ్ వాట్ కాల్ దో దెర్ ఈజ్ రేప్ ఇన్వాల్వ్డ్ or there is a kind of harassment involved, but more than harassment, what will happen is we see involvement of politics. It is the center and state political parties, right? They will manipulate the institutions. వాళ్ళ అంటే ప్రతి ఇన్స్టిట్యూషన్ వీళ్ళ కంట్రోల్లోనే ఉంటుంది. మీరు సిబిఐ తీసుకోండి, ఏ వ్యవస్థనే తీసుకోండి, అది వీళ్ళ కంట్రోల్లో ఉంటుంది. వీళ్ళు అంటే ఈ పొలిటికల్ పార్టీస్ ఏం చేస్తాయి అంటే, పార్టీస్ విచ్ ఆర్ ఇన్ పవర్, దే విల్ మ్యానిపులేట్ ది ఇష్యూస్, దే విల్ మ్యానిపులేట్ ది కేస్, దే విల్ manipulate the case in such a way that it will favor the political parties in power. So this is one thing. Alright, remember, and another major loophole is in the working of this NHRC is the recommendations given by NHRC. The recommendations given by NHRC are not binding on the government. So that is in the previous class I was saying that NHRC has all the powers of a civil court. Alright, NHRC has all the powers of a civil court. So as a civil court, alright, it can call for any kind of evidence, it can call for any kind of document, right? It can call for any public officer to be present. So it can that is NHRC has every power to take the evidence, right, to investigate the case, right, to call for any kind of document, to call for any kind of person, right? So anni jarute, and it can recommend a penal action, it can recommend a punishment. Now who should impose this punishment? It can recommend punishment to the government, either the state government or central government. So in most of the case it is state governments. Alright, in most of the cases it is state governments. So NHRC can recommend punishments, but the recommendations given by NHRC are not binding. These recommendations are not binding on the government. The recommendations given by NHRC are not binding on the government. Andukane most of the cases are investigated, but right, they are left at the stage of investigation. Or even if punishments are recommended, so sometimes we see governments changing the punishments. Instead of imposing the punishment as recommended by NHRC recommend చేసిన పనిష్మెంట్ని ఇంపోజ్ చేయకుండా స్టేట్ గవర్నమెంట్స్ ఏం చేస్తాయి, వాళ్ళకి కావాల్సిన పనిష్మెంట్ని అంటే దే విల్ చేంజ్ ద పనిష్మెంట్, దే విల్ ఆల్టర్ ది పనిష్మెంట్. సే ఫర్ ఎగ్జాంపుల్, ఇఫ్ ది let me take the case of custodial death. thing that NHRC has recommended, the ultimate disciplinary action against the concerned police officer, that is removal. అంటే ఎన్హెచ్ఆర్సీ రిమూవ్ చేయమని చెప్తే స్టేట్ గవర్నమెంట్స్ ఏం చేస్తాయి, రిమూవ్ చేయకుండా సస్పెండ్ చేస్తాయి, కొంతకాలం వరకు సస్పెండ్ చేయడం. అంటే అర్థం ఏంటిది, వీళ్ళు ఇచ్చిన రికమెండేషన్స్ వేరు, వాళ్ళు ఇంప్లిమెంట్ చేసే రికమెండేషన్స్ వేరు. అంటే వీళ్ళు ఎన్హెచ్ఆర్సీ ఇచ్చిన పనిష్మెంట్ వేరు ఉంటుంది, రైట్, ఆ స్టేట్ గవర్నమెంట్ ఇంపోజ్ చేసే పనిష్మెంట్ వేరు ఉంటుంది. సో ఇదే పెద్ద డ్రాబ్యాక్. మన దగ్గర వ్యవస్థలు ఉంటాయి, వీ హ్యావ్ ఇన్స్టిట్యూషన్స్, బట్ the effectiveness of institutions are always questioned. So these institutions, they are always manipulated. Alright, so this is about NHRC. So now if you take what you call appointing of NHRC, I have forgot to mention one point. I said that it is president who will appoint the members, but this appointment is made on the recommendations of a committee. The appointments are made on the recommendations made by a committee chaired by Prime Minister. Right? So it is the Prime Minister, right? It is a committee led by Prime Minister who will recommend the names. Right? It is a committee led by Prime Minister who will recommend the names to be President of India. Alright, so if you take this what you call composition of this committee, it consists of Prime Minister, Speaker of Lok Sabha. It consists of Prime Minister, Speaker of Lok Sabha, Deputy Chairperson of Rajya Sabha. Speaker of Lok Sabha, Deputy Chairperson of Rajya Sabha, leaders of opposition in both the houses. That is leader of opposition in Lok Sabha, leader of opposition in Rajya Sabha, Speaker of Lok Sabha, Deputy Chairperson of Rajya Sabha, and Union Home Minister. Prime Minister, inko vyakti Union Home Minister, and Union Home Minister. Right? So these are different members. These are different members of what you call committee. Right? So it is this committee that will recommend names to the NHRC. Right? Similarly, if you take what you call SHRC, it is governor appointing the what you call chairperson and other members of State Human Rights Commission. And coming to the committee, it is chaired by Chief Minister, consisting of Speaker of Assembly. In case of state, it is Speaker of Assembly. Alright? ఇక్కడ లోక్సభ, అక్కడైతే అసెంబ్లీ. రైట్? ఐదు పది మంది కాదు, ఎవరిని అపాయింట్ చేయాలో వాళ్ళ పేర్లే ఇస్తుంది. అందులో ప్రెసిడెంట్ ఇస్తామన్నట్టు ఉండదు, ఎవరిని అపాయింట్ చేయాలో వారి పేరు చెప్తుంది. ఓకేనా? 10 మంది లిస్ట్ ఇచ్చి అందుకే మీకు నచ్చిన వాళ్ళని అపాయింట్ చేసుకున్నట్టు కాదు, అలా ఉండదు. ఎవరినైతే ఐదుగురైతే అంటే the 5 members who are to be appointed, it is only that 5 members, not extra members or extra names are recommended. Alright? It is exactly what is required is recommended by committee. Alright? So this is about the appointment of the NHRC as well as SHRC. Alright? Take down a question on this. Take down a question on this. Explain the role of National Human Rights Commission. Explain the role of National Human Rights Commission. Explain the role of National Human Rights Commission. All right. and what is the effectiveness, and what is the effectiveness, what is the effectiveness of NHRC, what is the effectiveness of NHRC in its functioning, right, in its functioning. Alright. So next we move on to CVC, Central Vigilance Commission. Right. So vigilance. So keeping a vigil. Alright. So let me talk about CVC. Alright. So it is a Central Vigilance Commission. Alright. So what do you mean by vigilance? Keeping a vigil, that is keeping an eye on the working of public servants. Alright, it is focusing on the what you call working of public servants. Right, with an intention to control, corrupt practices. Right, with an intention to control corrupt practices. Right, the purpose of this vigil, the purpose of the vigil is to expose, all the corrupt practices. అంటే ఒకవేళ ఒక పబ్లిక్ సర్వెంట్ కరప్షన్లో ఇన్వాల్వ్ అయినా, కరప్ట్ ప్రాక్టీస్లో ఇన్వాల్వ్ అయినా దాన్ని ఎక్స్పోజ్ చేయడము అండ్ తగిన చర్యలు తీసుకోవడము. రైట్, టేకింగ్ అప్రోప్రియేట్ యాక్షన్ అగెయిన్స్ట్ ద కన్సర్న్ పబ్లిక్ సర్వెంట్ హూ ఈజ్ ఇన్వాల్వ్డ్ ఇన్ corrupt practices. Right, taking appropriate action against the public servant who is involved in corrupt practices. Right, so that is the intention of vigilance. Right, so if you take this genesis of Central Vigilance Commission, if you take the roots of Vigilance Commission, it is in the recommendations given by K. Santanam Committee. Right, in 1962. In 1962, the government of India has constituted a committee to recommend on, it has constituted a committee to make recommendations on prevention of corruption. So Santanam Committee is on. Santanam Committee is on prevention of corruption. It is a committee on prevention of corruption. Right. So this committee gave its recommendations in 1964. Right. సో ఇది ఒకటి ఇంపార్టెంట్, ఈ కమిటీ చాలా ఇంపార్టెంట్, మీకు ఎథిక్స్ పేపర్లో కూడా చాలా యూస్ఫుల్ అవుద్ది. రైట్, ప్రివెన్షన్ ఆఫ్ కరప్షన్. రైట్, ఇట్ ఈస్ అ కమిటీ ఆన్ ప్రివెన్షన్ ఆఫ్ కరప్షన్ వేర్ the committee submitted its report in 1964. The committee submitted its report in 1964. Alright, so it is this committee that actually recommended creation of institutions like vigilance commissions both in center as well as states. Right, so based upon the recommendations of Santanam Committee, right, Central Vigilance Commission as well as State Vigilance Commissions are created. So both CVC and SVC, both CVC and SVC came to existence. Both Central Vigilance Commission as well as State Vigilance Commission, they are created, they came to existence in what you call so CVC came to existence in 1963, whereas the SVCs, that is states have created their what you call State Vigilance Commissions in 1964 itself. Alright, states have created their vigilance commissions in 1964. Alright, so this is the establishment of CBC and SVC, right? So okay, so let me talk about the composition of Central Vigilance Commission. So if you take the composition of Central Vigilance Commission, this Central Vigilance Commission consists of a chairperson and 3 other members. All right. If you take this Vigilance Commission, sorry, it is a totally a 3-member body. It is totally a 3-member body where it consists of chairperson and 2 other members. It is chairperson and 2 other members, and all of them are appointed by President of India. All of them are appointed by President of India based upon the recommendations made by the committee. All right, the members of CVC. All right, the members of CVC are appointed by President on the recommendations of a committee chaired by Prime Minister. All right, it is the Prime Minister who is the chairperson. Normally MCQs అంటే ప్రిలిమ్స్ ఎగ్జామ్లో ఈ కమిటీస్ అపాయింట్మెంట్ కమిటీ ఉంటుంది కదా, అది ఇంపార్టెంట్. వాళ్ళు అడుగుతా అంటే ఎక్కువ అడిగే ఛాన్స్ అదే ఉంటుంది. రైట్, సో ఇఫ్ టేక్ దిస్ CVC, it is Prime Minister. Prime Minister తో పాటు లీడర్ ఆఫ్ అపోజిషన్ ఇన్ లోక్ సభ. ఇట్ ఈస్ లీడర్ ఆఫ్ అపోజిషన్ ఇన్ లోక్ సభ, అండ్ ది అదర్ పర్సన్ ఈస్ ఇట్ ఈస్ హోమ్ మినిస్టర్. ఇట్ ఈస్ హోమ్ మినిస్టర్. Prime Minister, leader of opposition Lok Sabha, and Union Home Minister. So this is the composition of the committee. All right. So till 2007, CVC was an executive body. All right. Till 2007, all right, CVC was an executive body. In 2007, a statutory status was given to CVC. Right, CVC got a statutory status in 2007. 2004లో బిల్ ఇంట్రడ్యూస్ చేస్తే 2007లో బిల్ పాస్ అయింది, ప్రెసిడెంట్ సంతకం అయింది. సో ఇన్ 2004 the bill was introduced in parliament, and in 2007 the president has given his assent on the law passed by parliament. That means officially from 2007, all right, this CVC has become a statutory institution. All right, so this is the what do you call composition of CVC, and what do you call appointment of CVC. All right, now coming to tenure of CVC. The tenure of CVC is 4 years. The tenure of CVC is 4 years. All right. So before 2007 it was 3 years. Later it was increased to 4 years. So now the tenure of CVC is 4 years. Okay. 6 years. The tenure of NHRC is 6 years. NHRC 5 years, 6 years, 5 years, 6 years. Let me check once. 5 years. మీరే చెప్పాలని చెప్పా. Whether CVC can take action directly or will make recommendations. That is what the doubt of Anusha. Whether CVC has a power to take a penal action or a penal action directly or can it recommend? And if it recommends, to whom CVC recommends? నిన్న మనం డిస్కస్ చేసిన ఈ పాయింట్. ఇన్ ఎస్టర్డేస్ క్లాస్ హ్యావ్ డిస్కస్ దిస్ పాయింట్. రైట్, యూపీఎస్సి గురించి మాట్లాడినప్పుడు yesterday in the previous class I was talking about Union Public Service Commission. Alright, the functions of UPSC. UPSC is indirectly involved in disciplinary actions. It is the President of India who has the ultimate disciplinary powers. It is President of India who has the ultimate disciplinary powers against all their service officers. Alright, so now on whose recommendations? Alright, on whose recommendations President of India will act, whether the recommendations of UPSC or the recommendations of CVC. నేను ఒక పాయింట్ చెప్పిన, the report of CVC is binding on President of India, where the opinion given by UPSC is advisory in nature. While taking a disciplinary action, the report given by CVC is binding on President of India. That means what? So CVC will recommend the action, right? It will recommend, it will send report to whom? It will recommend the report, it will recommend President of India. It will give the report to the President of India. So President of India, based upon the recommendations, based upon the report made by CVC, will take a disciplinary action. That means CVC will recommend what you call I'm sorry Amma, I'm sorry, the tenure of NHRC is 3 years. The tenure of NHRC is 3 years. I'm really sorry, అందుకే నాకు డౌట్ వచ్చింది. ఇది NHRC is 3 years. 3 years or until they attain the age of 70 years. I'm really sorry. Fundamental mistake from my side. The term of the tenure of NHRC is 3 years. ఇది కూడా ఈవెన్ CVC కూడా అంతే ఉండేది, 3 years ఉండింది. 2007లో it was increased to 4 years. Right? Alright, so this is about CVC. We take the functions of CVC. Right, CVC can take up, alright, CVC can take up any case of corruption against all India service officers, central class 1 service officers, central class 2 service officers, alright, officers posted in central public sector units, CPSCs. Alright, so it will it has the power to take up the cases against all India service officers class 1, that is group A, group B, and the officers posted in central public service units or public sector enterprises, PSUs or PSCs, right? And even, right, it can take up the cases of corruption in central paramilitary forces. Even the officers of central paramilitary forces, they are covered under CVC. It is not armed forces. Armed forces veru, central paramilitary forces veru. Alright, so central paramilitary forces sambandhina officers kuda, they come under the purview of CVC. So anyone, the central government, or you take the concerned ministry or any employee or anyone, even whistleblower, right? Even whistleblowers can raise the issue of corruption against public servants. Even whistleblowers can take up the case, can raise the issue of corruption case, right, against these officers. Alright, so మళ్ళీ ఇక్కడ ట్విస్టింగ్ పాయింట్ ఏంటిదంటే సిబిసి హ్యాస్ ఆల్ ద పవర్స్ ఆఫ్ సివిల్ కోర్ట్ బట్ it has no investigating agency of its own. It has no investigating agency of its own. So all the cases of CBC are investigated by Central Bureau of Investigation. It is Central Bureau of Investigation. It is Central Bureau of Investigation that will take up the cases of corruption. So it is CBI. It is CBI that will take up the cases of referred by CBC. Hello? చెప్పండి. యాజ్ ఆఫ్ నో ఏం లేదు. మళ్ళీ నాకు 12 కాల్ చేయండి, క్లాస్లో ఉన్నా. అవును, ఒక politician, right? They come under Lokpal. We have the institution of Lokpal that covers politicians, right? So CBC is meant only for public servants. CBC is strictly against public servants. Hello. So normally CBC uses Central Bureau of Investigation. It is CBI. It is CBI. Alright. So CBI is the investigating body of CBC. CBI is the investigating body of CBC. Alright. So all the cases of corruption taken up by CBC, they are what you call investigated by Central Bureau of Investigation. They are CBI, Government of India can constitute. It is not about the what you call case coming to CBC. It is Government of India on its own. Alright. So Government of India has raised an allegation against what you call Kejriwal. They impose the charges, and these cases based upon the documental evidences, the case is referred to what you call CBI. Alright. అవును, పొలిటీషియన్. సో అది లోక్పాల్కి వెళ్ళొచ్చు. లోక్పాల్కి వెళ్ళకుండా కూడా ఒక గవర్నమెంట్ ఇంకో గవర్నమెంట్ మీద, ఒక మినిస్టర్ ఇంకో ఆపోజిషన్ మినిస్టర్, దే కెన్ వాట్ యు కాల్ లోక్పాల్కి వెళ్ళాల్సిన అవసరం లేకుండానే, రైట్, లోక్పాల్కి వెళ్ళొచ్చు, లోక్పాల్కి వెళ్ళకపోవచ్చు. ఈవెన్ వితౌట్ గోయింగ్ టు లోక్పాల్, ఈవెన్ వితౌట్ రిపోర్టింగ్ ఇన్ లోక్పాల్, రైట్, ది గవర్నమెంట్ ఆర్ anyone can refer the case to the CBI, because CBI works under Ministry of Personnel. It is the government agency. It works under ministry, right? The minister can order the CBI to take up the case. Ardhamautunda? So the Government of India can use CBI because CBI is the agency of union government. So union government can use the CBI for investigating any cases, all the cases. So we have three wings in what you call CBI. We have what you call economic offences wing, right? We have economic offences wing, and there is separate enforcement directorate. So all they work under this union government, right? So they can use this, they can refer the case to this EDs or what you call CBIs. Andukane CBI ED మీద పెద్ద జోకులు ఉంటాయి. They are not what you call independent institutions. They are the institutions of what you call political parties. They are used by political parties against their rival politicians, right? Against their rival politicians. నిన్న ఇప్పుడు జగన్ మోడీని కలిసిండ, పోయి జగన్ మీటింగ్ అయింది ఏమన్నా? నేను ఎగ్జాక్ట్గా మొత్తం న్యూస్ చూడలేదు. అది ఎప్పటికి ఉండేది, కానీ నిన్న ఏదో ఏబిఎన్ ఆంధ్రజ్యోతిలో చూస్తున్నా, ఐ వాస్ సీయింగ్ అ పిక్చర్ ఆఫ్ మోడీ అండ్ జగన్, రైట్. లోక్పాల్ కూడా తన సొంతంగా ఇన్వెస్టిగేషన్ ఏజెన్సీ లేదు, అది కూడా మళ్ళీ ఇట్ కెన్ అసెండ్ ద కేసు టు సిబిఐ. సో ఇక్కడ మీరు అడిగే క్వశ్చన్ ఏంటిదంటే, పొలిటీషియన్స్ మీద కేసెస్ని తప్పనిసరిగా అంటే లోక్పాల్కి వెళ్ళిన తర్వాతనే ఇన్వెస్టిగేషన్ జరగాలని మీ క్వశ్చన్. ఇప్పుడు నేను చెప్పే ఆన్సర్ ఏంటంటే, లోక్పాల్కి వెళ్ళొచ్చు, వెళ్ళక ముందే, రైట్, లోక్పాల్లో ఫైల్ చేయకముందే, రైట్, యూనియన్ గవర్నమెంట్ కెన్ డైరెక్ట్ ది CBI, it can direct the enforcement directorate to investigate the case. లేదు. సో లోక్పాల్ కూడా there is no separate institution. So Lokpal is again dependent on this CBI like institutions. Or Lokpal can constitute its own investigating body for time being, right? It can constitute what we call investigating body, drawing officers from center as well as states. Lokpal konna 2013 tarvata there was changes made to Lokpal, which is called as Jan Lokpal, right? So according to Jan Lokpal Act, the Lokpal, right, can constitute its own investigating body, and it can provide time frame for that investigating body to investigate the case. సంవత్సరాలు తీసుకుంటే కుదరదు. సో లోక్పాల్ విల్ ప్రొవైడ్ అ స్పెసిఫిక్ టైమ్ ఫర్ ఇన్వెస్టిగేషన్. నాకు 3 నెలల్లో ఇన్వెస్టిగేషన్ అయిపోవాలి, 4 నెలల్లో ఇన్వెస్టిగేషన్ అయిపోవాలి అంటే ఎంత టైంలో ఇన్వెస్టిగేషన్ అయిపోవాలో కూడా లోక్పాల్ చెప్తుంది. ఒకప్పుడు ఎలా ఉండిందంటే, ఒక కేసు తీసుకుంటే సంవత్సరాలు పట్టేది ఆ కేసు మీద, ఇప్పుడు అలా లేదు. సో లోక్పాల్ కెన్ క్లియర్లీ స్పెసిఫై అ స్పెసిఫిక్ టైమ్. ఇట్ కెన్ స్పెసిఫై ద స్పెసిఫిక్ టైమ్ ఫర్ ఇన్వెస్టిగేషన్, అండ్ లోక్పాల్ కెన్ కాన్స్టిట్యూట్ ఇట్స్ ఓన్ ఇన్వెస్టిగేటింగ్ బాడీ. అంటే కంప్లీట్గా సిబిఐకి ఇవ్వడమో లేకపోతే కంప్లీట్గా స్టేట్ ఏజెన్సీకి ఇవ్వడమో కాదు. సో సెంటర్ నుంచి స్టేట్ నుంచి ఒక ఆఫీసర్స్ని డ్రా చేసుకొని, అంటే డిప్యుటేషన్ మీద పెట్టేసుకొని ఒక టీంని కాన్స్టిట్యూట్ చేసి ఆ టీం ద్వారా ఇన్వెస్టిగేట్ చేయించడం. సో ఆ టీం ఎవరన్నది లోక్పాల్ డిసైడ్ చేస్తుంది. ఆ టీంలో ఎవరు ఉండాలి, ఆ టీం ఏంటిది అన్నది లోక్పాల్ డిసైడ్ చేస్తుంది. ఒకప్పుడు అలా ఉండేది కాదు. కేసుని రైట్ సిబిఐకి డైరెక్ట్గా అప్పగించడం లేదా స్టేట్ ఏజెన్సీకి అప్పగించడం, ఇప్పుడు అలా కాదు, రైట్. సో లోక్పాల్ హ్యాస్ ద పవర్ టు కాన్స్టిట్యూట్ ఇట్స్ ఓన్ ఇన్వెస్టిగేటింగ్ టీమ్, drawing officers from center as well as states, all right. So this is all right. నేను ఒక స్టేట్మెంట్ చూసిన ఏంటంటే, 10% రూల్ అన్నది 10% మెంబర్షిప్ అన్నది మనకి ఎలాంటి చట్టం లేదని జగన్ పార్టీ చెప్పింది. 10% రూల్ అవసరం లేదు టు గివ్ ద స్టేటస్ ఆఫ్ అపోజిషన్ పార్టీ. దేర్ ఈస్ నో లా రిక్వైరింగ్ 10% members. Do we have a law or not? So we don't have a law in constitution, but in 1967 what happened? In 1967 parliament has made a law, right? 1967 lo parliament has made a law saying that, right, the political party that has, right, at least 1/10 of total members of Lok Sabha in case of parliament, 1/10 of total members of assembly in case of what you call state legislature, will be given the status of leader of opposition, to be that recognized opposition, right, to be called as recognized opposition. Ikkada opposition party kaadu, recognized opposition party. To get recognized as an opposition party, it requires at least 1/10 of the members, right, officially, because the leader of largest opposition party has a what you call a rank of cabinet minister. Adi gurtu pettukovali. The leader of largest opposition party has the status of cabinet rank, right. So no doubt Jagan party is the opposition party, అందులో డౌటే లేదు, right. It is opposition party, but he won't get the status of cabinet minister. He will be recognized as leader of opposition. అందులో పెద్ద ఇష్యూ కాదు అది. He is ultimately the leader of opposition, but he don't enjoy the status of a cabinet minister. క్యాబినెట్ మినిస్టర్ స్టేటస్ ఉండాలి అంటే, ఆ హోదా రావాలి అంటే, ఆ అపోజిషన్ పార్టీస్కి అట్లీస్ట్ 1/10 ఆఫ్ టోటల్ మెంబర్స్ ఉండాలి. 175 కదా, 17.5 అంటే 18 సీట్స్ ఉండాలి. 18 సీట్స్ ఉంటేనే జగన్కి క్యాబినెట్ స్టేటస్ ఉంటుంది, క్యాబినెట్ మినిస్టర్ స్టేటస్ ఉంటుంది, లేకపోతే ఉండదు. హీ ఈజ్ ది లీడర్ ఆఫ్ అపోజిషన్, నో డౌట్ ఇన్ దట్. రైట్. అంటే కొన్నిసార్లు ఏమనిపిస్తుంది అంటే, ఈ పొలిటీషియన్స్కి ఎలక్షన్స్ అయిపోయిన తర్వాత ఒక 2 నెలలు ట్రైనింగ్ చేయాలనిపిస్తుంది. అట్లీస్ట్ కాన్స్టిట్యూషనల్ లాస్ ఏంటివి, ఈ పార్లమెంటరీ లాస్ ఏంటివి, ఎంత మిజరబుల్ పొజిషన్ ఉంటారంటే కనీసం వాళ్ళు చేసే పని వాళ్ళకు అంటే దే డోంట్ నో ద రూల్స్ అండ్ రెస్పాన్సిబిలిటీస్ రైట్ ఆఫ్ దెమ్. ఎవరికి అది ఫార్మాలిటీ, కంపల్షన్ కాదు కదా. ఇట్ ఈస్ నాట్ అ లా, ఇట్ ఈస్ ట్రెడిషన్. How according to the laws of Lok Sabha, how deputy speaker is chosen? It is by election, right? Deputy speaker is also elected in the same manner as that of speaker of Lok Sabha. Lok Sabha speaker ni ela ennukuntaro, deputy speaker ni kuda alane ennukovali, adi rule. కానీ మనం ఆ రూల్ని ఫాలో కాకుండా ఒక ఆనవాయితీని పెట్టుకున్నాం, ఒక ఫార్మాలిటీని పెట్టుకున్నాం. ఏంటిదంటే స్పీకర్ రూలింగ్ పార్టీ నుంచి, డిప్యూటీ స్పీకర్ అపోజిషన్ పార్టీ నుంచి అని అనుకున్నాం. అది తప్పనిసరి కాదు కదా. ఇట్ ఈస్ నాట్ అ కంపల్షన్. సో యూ షుడ్ ఫాలో ద రూల్స్, రైట్. నౌ వెదర్ ఇట్ ఈస్ మ్యాండేటరీ టు ఎలెక్ట్ డిప్యూటీ స్పీకర్. లాస్ట్ ఎలక్షన్ ముందు పెద్ద డిబేట్ జరిగింది. ఎందుకంటే ఇండియాలో ఒక సంవత్సరం పాటు దేర్ ఇస్ నో డిప్యూటీ స్పీకర్. వెదర్ ఇట్ ఈజ్ మ్యాండేటరీ. నరేంద్ర మోడీ ప్రీవియస్ గవర్నమెంట్ అంటే దీనికన్నా ముందు గవర్నమెంట్లో డిప్యూటీ స్పీకర్ లేడు. ఇప్పుడు క్వశ్చన్ మార్క్ వచ్చింది, వెదర్ డిప్యూటీ స్పీకర్ ఈజ్ మ్యాండేటరీ. వెన్ డిప్యూటీ స్పీకర్ విల్ చైర్ ద హౌస్, వాట్ ఈస్ ద కండిషన్? వెన్ దేర్ ఈజ్ అ టెంపరరీ absence ఆఫ్ స్పీకర్. వెన్ దేర్ ఈస్ ప్రెసెన్స్ ఆఫ్ స్పీకర్, విల్ దేర్ బి ఎనీ యూజ్ ఆఫ్ డిప్యూటీ స్పీకర్? స్పీకర్ అన్నప్పుడు డిప్యూటీ స్పీకర్ అవసరం లేదు. అంటే అర్థం ఏంటిది? కాన్స్టిట్యూషన్ ఆఫ్ డిప్యూటీ స్పీకర్ ఈజ్, that is election of deputy speaker is not mandatory. If he is elected, it is in the same manner as that of speaker of Lok Sabha. So election of deputy speaker అనేది తప్పనిసరి కాదు. ఎందుకు అంటే డిప్యూటీ స్పీకర్ అన్నవాడు స్పీకర్ ఆఫీస్లో లేనప్పుడు మాత్రమే చేస్తాడు, అంటే he will officiate. But when speaker is in house, when speaker is in what you call office, there is no question of having deputy speaker. అలాంటప్పుడు ఎలక్ట్ చేయాల్సిన అవసరం ఏముంది? స్పీకర్ ఆఫీస్లో ఉన్నప్పుడు స్పీకర్ నేను ఎప్పుడు యాబ్సెంట్ కాను అనుకున్నప్పుడు వాట్ ఈస్ ద యూజ్ ఆఫ్ హ్యావింగ్ దిస్ వాట్ యు కాల్ డిప్యూటీ స్పీకర్? రైట్. మళ్ళీ ఇంకోటి ఏంటిది, ఇన్ కేస్ ఆఫ్ టెంపరరీ యాబ్సెన్స్, ఇన్ కేస్ ఆఫ్ పర్మనెంట్ యాబ్సెన్స్ ఆఫ్ స్పీకర్, వెదర్ డిప్యూటీ స్పీకర్ కెన్ చైర్ ద హౌస్. సో మనం ఇక్కడ రెండింటిని మనం గమనించాలి. యూ షుడ్ థింక్ అబౌట్ 2 things. One is right temporary absence, other one is permanent absence, right? We are saying that in case of temporary absence, it is deputy speaker. In case of temporary absence, it is deputy speaker who will preside the house. But what about the case of permanent absence? In case when there is a permanent absence, in case of permanent absence, what about who will chair the house? మన డిప్యూటీ స్పీకర్ని యాక్ట్ చేయాలంటే కండిషన్ ఏంటిది? ఓన్లీ టెంపరీ యాబ్సెన్స్లోనే. మరి పర్మనెంట్ వేకెన్సీ వచ్చినప్పుడు అప్పుడు ఖచ్చితంగా ఎలక్షన్స్ పెట్టాల్సిందే. మరి ఎలక్షన్స్ అయ్యేంత వరకు ఎవరు ఉండాలి? ప్రోటమ్ స్పీకర్. గుర్తుపెట్టుకోండి, ఇట్ ఈస్ అగైన్ ప్రోటమ్ స్పీకర్. సో ప్రోటమ్ స్పీకర్ విల్ చైర్ ద హౌస్, రైట్? ఇట్ ఈస్ pro tem speaker who will chair the house in case when there is permanent vacancy, when there is permanent absence. Permanent absence lo unnappudu, permanent vacancy unnappudu, right, it is what you call pro tem speaker. It is pro tem speaker who will chair the house, right? Okay, మనం చాలా డైవర్ట్ అయిపోతున్నాం, right? We are getting diverted. So if you take this CVC, so CVC will take up the cases against case of corruption against what you call only service officers, central government officers of rank of class 1 and class 2, right? Officers serving in central public sector units, right? వాళ్ళు ఇచ్చేని బట్టి రిమూవల్ ఉంటుంది. బైండింగ్ చేసినప్పుడు తప్పు, అది పాలిటిక్స్, అది రైట్. పాలిటిక్స్ మనం అఫీషియల్గా చెప్తామా? ఇట్ ఈస్ అన్అఫీషియల్, రైట్. So we know that there is politics involved, but it is unofficial. Officially there is no politics. Alright. So this is what about, alright, Central Vigilance Commission. So the problem here is that is CVC entirely depends upon CBI. Alright. Now coming to CBI unofficially it is under the control of political system. Alright. So even though there are reports of corruption, even though there are what you call charges of corruption, right, and even when the case is referred to CBI, what will happen? Alright, it is a political influence. It is a political influence on CBI which will determine the work of CBI. Alright. So today in India, not just CBI, we see every institution being politicized. Alright. We see politicization of all the constitutional and extra constitutional bodies. So this is the reason for ineffectiveness. This is the reason for ineffective working of these institutions. Right. The reason for ineffective working of these institutions is politicization. Right. They are placed under political system. Right. అలానే కదా మీకు చెప్పాలనుకుంటే చాలా ఉంటుంది. రైట్. మీరు ఆంధ్ర పాలిటిక్స్ కానీ తెలంగాణ సెంటర్ స్టేట్ రిలేషన్స్, సెంటర్ ఆల్వేస్ కంట్రోల్ స్టేట్స్. హౌ ఇట్ కంట్రోల్ స్టేట్స్? బై యూజింగ్ దీస్ ఇన్స్టిట్యూషన్స్. మెయిన్లీ ఇట్ ఈస్ సివిసి, సిబిఐ, ఎన్ఫోర్స్మెంట్ డైరెక్టరేట్. సో ఇట్ ఈస్ దీస్ ఇన్స్టిట్యూషన్స్. బికాస్ వాళ్ళకు తెలియకుండా ఏది జరగదు. రైట్. నేను చెప్తున్నా కదా, ₹1 ట్రాన్స్ఫర్ అయినా కానీ గవర్నమెంట్ తెలిసిపోతుంది, యూనియన్ గవర్నమెంట్ తెలిసిపోతుంది. బికాజ్ ఐ హ్యావ్ మై ఫ్రెండ్స్ ఇన్ వర్కింగ్ ఇన్ దిస్ ఇంటెలిజెన్స్ వింగ్స్. వాళ్ళు చెప్తారు, ఈవెన్ మేము డబ్బులు ఇద్దామనుకున్నా, మాకు డబ్బులు ఇవ్వాలనుకున్నా వాళ్ళు ఇవ్వరు. మాకు ఫ్రెండ్స్ అయినా సరే ఇవ్వరు. ఎందుకంటే ఈవెన్ కంప్లీట్ విజిలెన్స్ ఉంటుంది. టుడే ఎవ్రీథింగ్ ఈజ్ కంప్యూటరైజ్డ్. రైట్. విత్ ఇన్ డేస్ డబ్బులు ఏ అకౌంట్ నుంచి ఏ అకౌంట్కి ట్రాన్స్ఫర్ అవుతుంది. సో వాళ్ళకి ప్రతి ఇన్ఫర్మేషన్ ఉంటుంది. గవర్నమెంట్కి పర్టికులర్గా దెర్ ఈస్ వన్ వింగ్ కాల్డ్ యాజ్ డైరెక్టరేట్ ఆఫ్ రెవెన్యూ ఇంటెలిజెన్స్, DRS. సో నా రూమ్మేట్ ఈస్ వర్కింగ్ యాజ్ కమిషనర్ ఇన్ DRI. రైట్. సో వాళ్ళకి ఎలా ఉంటుందంటే ప్రతిదీ, ఈవెన్ దే హ్యావ్ ఇన్ఫర్మేషన్ అబౌట్ ట్రాన్స్ఫర్ ఆఫ్ ₹1 ఫ్రమ్ వన్ డిపార్ట్మెంట్ టు ది అదర్ డిపార్ట్మెంట్, ఫ్రమ్ వన్ అకౌంట్ టు ది అదర్ అకౌంట్. విజిలెన్స్ చాలా స్ట్రాంగ్గా ఉంటుంది. కాకపోతే దాన్ని ఏమంటే ఇట్ ఈస్ డైల్యూటెడ్. Right, because of political influence it is diluted. If the civil service system, if public servants are given free hand, ఇండియాలో కరప్షన్ ఉండదు. వాళ్ళకి ఫ్రీ హ్యాండ్ ఇస్తే ఎలాంటి కరప్షన్ ఉండదు. కాకపోతే ఏంటంటే వాళ్ళకి ఫ్రీ హ్యాండ్ ఇవ్వరు ఎందుకంటే బికాస్ ఇట్ ఈస్ ది పొలిటికల్ పవర్, ఇట్ ఈస్ ది పొలిటికల్ రిలేషన్స్. రైట్. సో దిస్ ఈస్ అబౌట్ what you call Central Vigilance Commission. All right. Next, coming to Lokpal. Coming to Lokpal, the institution of Lokpal. If you take this institution of Lokpal, all right, so we have a long history of institution of Lokpal. Sweden is the first country. Sweden is the first country, all right, to start this institution of Lokpal. Sweden is the first country to start the institution of Lokpal, all right, where it is called as ombudsman system. Ombudsman. So, in India, we use the term Lokpal, but in different countries they have their own name. Ombudsman is one such name. Ombudsman, procurator system, right? Parliamentary commissionerate system. So these are different names, right? Procurator, right? Parliamentary commissioner. Parliamentary commissionerate system. And India we use the word Lokpal. India we use the word Lokpal. Right? So Lokpal and Lokayukta. Lokpal and Lokayukta. Alright. So Sweden is the first country to start this system in 1809. Then this is followed in communist countries like Hungary, Russia, right, Czechoslovakia. It was in these countries where this procurator system was followed. And if you take this parliamentary commissionerate system, it was used by, it is being used by what you call Commonwealth countries. It is used by Commonwealth countries, that is those countries which were colonies of Britain, right? And New Zealand is the first country to start this parliamentary commissionerate system in 1961, right? Britain had started this parliamentary commissionerate system in 1967, and in India for the first time the word Lokpal was used in 1968, right? Remember Santanam committee, it was Santanam committee which actually recommended constitution of Lokpal, alright? Santanam committee has recommended constitution of Lokpal and Lokayukta and based upon the recommendations of Santanam committee, for the first time a bill was introduced in parliament, right? For the first time a Lokpal bill was introduced in 1968, right? For the first time it was not only Santanam committee but even first ARC, first Administrative Reforms Commission. The first Administrative Reforms Commission in 1966 has recommended constitution of Lokpal, right? So both Santanam committee as well as if you take first ARC, right? Both these committees have recommended constitution of Lokpal, right? For the first time it was in 1968, right? The Lokpal bill was introduced. Kani 2013 వరకు 2001 వరకు ఎలాంటి ఆ బిల్లు ల్యాబ్స్ అవ్వడము, మళ్ళీ రీఇంట్రడ్యూస్ అవ్వడం, మళ్ళీ ల్యాబ్స్ అవ్వడం అలా జరుగుతూ వచ్చింది, రైట్? సో a Lokpal Act was passed, right? For the first time, right, a Lokpal Act was passed in 2011. లో లోక్పాల్ బిల్ వాజ్ ఇంట్రడ్యూస్డ్. యాక్ట్ పాస్ కాలేదు, లోక్పాల్ బిల్ వాజ్ ఇంట్రడ్యూస్డ్, దేర్ వాజ్ అ డిస్కషన్. బట్ in 2011, right, a big event took place, that is a nationwide movement was launched to bring changes to the Lokpal bill. రైట్. సో లోక్పాల్ బిల్ 2011లో ఇంట్రొడ్యూస్ చేసిన లోక్పాల్ బిల్ మీద చేంజెస్ తీసుకురావాలని ఒక మూమెంట్ స్టార్ట్ అయింది. దట్ మూమెంట్ వాజ్ లాంచ్డ్ బై అన్నా హజారే, రైట్, which is called as Jan Lokpal Bill, right. So they demanded changes to the Lokpal. So it was a movement launched by Anna Hazare, Arvind Kejriwal limelight loki vachindi aa movement nunchi. The name of Arvind Kejriwal came to limelight and people came to know about Arvind Kejriwal only in this what we call Jan Lokpal Bill movement, all right. So as a supporter of Anna Hazare, as a follower of Anna Hazare, Arvind Kejriwal led this movement, right. He led this Jan Lokpal movement, and in 2013 what you call for the first time, right, the parliament has passed this Lokpal bill. This Jan Lokpal bill was passed in 2013, all right. ఈ స్ట్రక్చర్ కొంచెం కాంప్లెక్స్ ఉంటుంది, అంతే ఒకసారి చెప్తే అర్థం కాదు మీకు. బట్ రీడ్, ఎందుకంటే యూ హ్యావ్ సమ్ కైండ్ ఆఫ్ కాంప్లెక్సిటీ ద స్ట్రక్చర్ ఆఫ్ what you call in the composition of Lokpal, because changes were made. There are many ifs and what you call buts in this what you call Lokpal bill. So read Lokpal bill, but I'll give the outlines of the structure. So if you take this Lokpal consists of chairman and 8 other members. It is a 9-member body. It is a 9-member body. All right, and this chairman is normally a retired CJ of Supreme Court, right. He is normally a retired CJ of Supreme Court or a former judge of Supreme Court, right. A retired CJ of Supreme Court or a former judge of Supreme Court who has a wide experience in the matters of corruption, at least who has an experience of 25 years in the field of యాంటీ కరప్షన్. అంటే యాంటీ కరప్షన్లో ఒక 20 సంవత్సరాలు పనిచేసిన వాడై ఉండాలి. Alright, so you should have been working in the field of anti-corruption for at least 25 years. So this is one of the impeccable record. వాళ్ళు 2016లో ఒక చేంజెస్ తీసుకొచ్చిండు, right. So according to this, the Lokpal and other members of this the Lokpal and other members, they should be experts, they should be the eminent persons, they should have an expert knowledge in the field of what we call anti-corruption, right. Next, ఇందులో ఇంకొకటి ఏంటిదంటే of these 8 members, right, ఈ 8 మెంబర్స్లో half are from judiciary, 4 should be from judiciary, alright. Next, ఇంకో కండిషన్ అంటే అవుట్ ఆఫ్ దిస్ 8 members 50% should be what you call members from SC, ST, OBCs and women. అంటే 50% should be from these categories. అంటే 50% జనరల్ కేటగిరీ అయితే 50% SC, ST and women, రైట్. సో విమెన్ కెన్ బి ఫ్రమ్ దీస్ గ్రూప్స్ ఆర్ ఫ్రమ్ జనరల్ కేటగిరీ. అంటే మొత్తంగా 50% రిజర్వేషన్ ఉంటుందన్నమాట. ఈ 50% రిజర్వేషన్ ఎవరికి అంటే ఈ అందరు కలిపి 50%, రైట్. సో దట్ ఈస్ వాట్ ది కండిషన్, రైట్. సో అండ్ ఆల్ దే ఆర్ అపాయింటెడ్ బై ప్రెసిడెంట్ ఆఫ్ ఇండియా. What you call appointed by President of India for a term of 5 years or until they attain the age of 70 years. Their tenure, the tenure of Lokpal is 5 years or until they attain the age of 70 years. Alright. So the President will appoint these members based upon the recommendations made by based upon the recommendations made by a committee chaired by Prime Minister. Alright, so it is the president who will appoint the members, no doubt in that. కానీ ఇక్కడ alright, it is the committee that is headed by Prime Minister. Right, so if you take this committee, alright, this committee consists of Prime Minister, CJ of Supreme Court or any eminent judge nominated by CJ of Supreme Court. CJ of Supreme Court ఉండొచ్చు లేదా అతని రిప్రజెంటేటివ్, దట్ ఈస్ ద పర్సన్ హూ ఈస్ nominated by CJ of Supreme Court. The person who is nominated by CJ of Supreme Court. One eminent jurist, leader of opposition in Lok Sabha, Speaker of Lok Sabha. Alright, so these are different members. Alright, who will be recommending the names? To the appointment of Lokpal. Alright, so if you take this institution of Lokpal, this Lokpal can entertain a case of corruption against politicians, including Prime Minister. Lokpal ke Jan Lokpal teda ade. Jan Lokpal lo, right, Prime Minister was included. Even the cases of corruption against Prime Minister can be investigated. They can be raised in Jan Lokpal. ఇంతకు ముందు అంటే 2013కి ముందు Jan Lokpal రాకముందు Prime Minister was not included. Right, so Prime Minister was not included before what you call this passing of Jan Lokpal bill. Right, that is the reason. That means even the Prime Minister is not exempted from the case of corruption. అందుకనే మీరు చూడండి మన్మోహన్ సింగ్ లాస్ట్ 2 yearsలో there were corruption cases filed against Manmohan Singh in Lokpal. Coal scam, Colgate scam, even there were charges against Prime Minister of India. It was said that even Prime Minister was involved in this corruption, but of course they are not been proved. Right, so Prime Minister was not proved. The allegations against Prime Minister were not proved, but the allegations against other ministers were proved and they were sent to jail. అంతేందుకు మన ఏపీ నుంచి దాసరి నారాయణ రావు పేరు గుర్తుంటుంది మీ అందరికీ, చనిపోయింది ఇప్పుడు, మూవీ డైరెక్టర్ తెలుసా, దాసరి నారాయణ రావు. రైట్, సో హీ వాజ్ ది యూనియన్ కోల్ మినిస్టర్ ఇన్ వాట్ యు కాల్ డ్యూరింగ్ మన్మోహన్ సింగ్ గవర్నమెంట్. During Manmohan Singh government, he was union coal minister. He was sentenced to jail. In the case of corruption case, that is, there was a issue of allocation of coal blocks. Right, there was corruption in the allocation of coal blocks. Right, so in this case, right, the coal minister was arrested. Alright, that means Lokpal can entertain. Lokpal has the power to take up the cases even against politicians, including Prime Minister. So Lokpal lo there was no Prime Minister included, but it was included in Jan Lokpal. Anusha cheppu. Evaraina sare, as the acting politicians or the previous ones, they can be allegations, they can be investigated. Right, they can be investigated. So Lokpal can investigate. Lokpal has the power to constitute its own investigating team. Lokpal will determine the time frame within which the investigation should be done, and based upon the report of investigation, the Lokpal has the power to impose punishments directly. So the Lokpal will not recommend, Lokpal will impose the punishments directly. Intamundu if you take CVC or NHRC, they can recommend punishments. Can ikkada entadi Lokpal on its own can impose the punishments. Right, so this is about Lokpal. So Lokpal is in the center, and same as Lokpal, we have Lokayuktas in each and every state. Right, we have the system of Lokayukta in every state. Alright, so Maharashtra is the first state in the country to start the system of Lokayukta. కానీ ఒక వింత ఏంటంటే even before Maharashtra, it was Orissa who actually passed the Lokayukta Act for the first time. Right? Though Orissa passed the act for the first time, but the institution was created after much gap. Whereas Maharashtra is the first state to institute the institution of Lokayukta, create the institution of Lokayukta. ఇక్కడ చూడండి, యాక్ట్ ఫస్ట్ పాస్ చేసింది ఒరిస్సా, కానీ ఫస్ట్ ఇన్స్టిట్యూషన్ క్రియేట్ చేసింది మహారాష్ట్ర. ఈ తేడా గుర్తుపెట్టుకోండి. నార్మల్గా మీ గ్రూప్స్ ఎగ్జామ్ లాంటి వాటికి పనికొస్తాయి ఇలాంటివి. రైట్. So what is and if you take this Lokayukta is involved in investigating the cases of corruption against politicians. Ikkada we don't have uniformity in the Lokayukta system. Anni states lo, right, we don't have the same kind of Lokayukta system. We don't have the same kind of Lokayukta system in all the states. Right. There is a change in the Lokayukta system. Right? There is a change in Lokayukta system. Right? In some states, right, chief ministers are covered within Lokayukta. In some states, in some other states, the CMs are not covered within Lokayukta. Right? In some states, those CMs are covered, but right, without providing notice, they cannot be arrested. So there is a differences in the system of Lokayukta. ఏ స్టేట్కి ఆ స్టేట్ తగ్గట్టు వాళ్ళు లోకాయుక్తాన్ని క్రియేట్ చేసుకున్నారు. రైట్. మనకు ఒక యూనిఫార్మిటీ సిస్టమ్ లేదు. అది అది వాళ్ళ ఇష్టం, అది వాళ్ళ ఇష్టం అది. రైట్. దెర్ ఇస్ నో కంపల్షన్. ఇట్ ఈస్ అప్ టు ది what you call states. So every state has Lokayukta system. It is up to the states to go to create these Lokayuktas. Right. So this is about the system of Lokpal and Lokayukta. Right. Next, let me talk about Right to Information Act, RTI. Right. Right to information comes under which article of Indian Constitution? Right to information comes under which article? Right. We have right to information and freedom of information. Freedom of information. So right to information comes under which article? 19. Not 19. 19 కాదు. Whether right to information is a part of right to life and liberty? Can we regard right to information as a part of right to life and liberty? Yes or no? Yes. Right to information. Right to information is a part of right to information is a part of right to life and liberty. That means right to information is also a part of Article 21. Freedom of information is Article 19. Right. Freedom of information is Article 19. Alright. So if you take what you call if you take this history of right to information. So if you take traditionally Indian administration is governed by one act called as Official Secrecy Act. For the first time it was passed in 1896. Then in 1924, right, it is a British era act. Right. This Official Secrecy Act. Right. Official Secrecy Act. Right. So Indian administration traditionally it is governed by, traditionally it is governed by this Official Secrecy Act. Alright, that means the entire administration is maintained, it is maintained secretly, that is there is secrecy in administration. The citizens are not allowed to know what is going within the administration. Alright, so Supreme Court in Association for Democratic Reforms case, Supreme Court in PUCL case, right? Supreme Court in Subhash Agarwal case, right? In all these cases, held that right to information is a part of right to life and liberty of individuals. So, right to information is regarded as a fundamental right of the individuals, right? So, in 1997, it was in PUCL versus Union of India case, right? In 2002, it was in what you call ADR versus what you call Union of India case, that is Association for Democratic Reforms case, right? In these cases, it was in these cases Supreme Court held that right to information is a fundamental right, right? So for the first time, alright, in 2002, for the first time, after this judgment in ADR case, right, Supreme Court made this right to information as a fundamental right. And another movement, so we had a movement launched by Aruna Roy, right? So according to the movement launched by Aruna Roy, right? So she had her own organization, that is Kisan Shakti Sangathan. So it was a movement launched by Kisan Shakti Sangathan in Rajasthan. It is this movement, right, which has demanded right to information, right? So it is a movement launched by Aruna Roy and Kisan Shakti Sangathan. It is a movement launched by Aruna Roy and Kisan Shakti Sangathan. Alright, this right to information was passed. Right, right to information was passed based upon this movement. So it was in 2005. Right to information was passed. Alright. So today it is a fundamental right. So right to information is an fundamental right. It is an fundamental right. Okay. So according to this Right to Information Act, it is the duty, it is an obligation on a public servant to provide information within a period of 30 days of application. Application వచ్చిన 30 days లోపల information ఇవ్వాలి. Right? In case if information is not provided within given time, there will be a penal action including penalties. Right? Including penalty as well as a penal action can be imposed. Right? So this is access, and this Right to Information Act, right, according to Right to Information Act, right, Central Information Commission, State Information Commission as well as District Information Commission is created, right? So according to RTI Act of 2005, Central Information Commission, State Information Commission as well as District Information Commission is created, right? So this is what about Right to Information Act. So for today's of the class here, right, in one more class I'll complete this CIC, SIC and what you call anti-defection law. Alright, and after completing that I'll start economy parallelly. Okay, for now I'll start the class here. Alright, we'll meet in next class. Okay. And remember, from next class onwards, the class will be on the app, not on YouTube. Alright? The next class will be on app. The one who are interested to join, please download the app and join the class.